Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. I will now instruct you as to the law that governs this case. You have been handed a copy of the instructions. I will read. You should feel free to read along with me or to just listen to me. You will be able to make your copy of the instructions into the jury room, and you will be able to consult these instructions during your deliberations. There are 3 parts to these instructions. First, I'll give you general instructions about your role and about how you are to decide the facts of the case. For example, what happened. Second, I'll give you instructions as to the specific charges in this case. Third, I'll give you some final instructions about procedure. It is important that you listen carefully. I am reading these instructions from a prepared text because the law is made up of words that are very carefully chosen. This is not a time to ad lib. When I tell you what the law is, it's critical that I use exactly the right words. My duty at this point is to instruct you as to the law. It is your duty to accept these instructions of law and to apply them to the facts as you determine them. With respect to legal matters, you must take the law as I give it to you. If any lawyer has stated a legal principle different from any that I state to you in my instructions, it is my instructions that you must follow. You are to consider these instructions together as a whole. In other words, you are not to isolate or give undue weight to any particular instruction. You must not substitute your own notions or opinions of what the law is or what it ought to be. As members of the jury, you are the sole and exclusive judges of the facts. You decide what happened. It is your sworn duty to determine the facts based solely on the evidence received in this trial. Any opinion I might have regarding the facts is of absolutely no consequence. The personalities and the conduct of counsel in the courtroom are not in any way at issue. If you formed an opinion of any kind as to any of the lawyers in the case, favorable or unfavorable, whether you approved or disapproved of their behavior as advocates, that should not enter into your deliberations. The lawyers and I have had sidebar conferences and other conferences out of your hearing. These conferences involved procedural and evidentiary matters and should not enter into your deliberations at all. A lawyer has a duty to object when the other side offers testimony or other evidence that the lawyer believes is not admissible. It is my job to rule on these objections. Why an objection was made or how I ruled on it is not your concern. You should not draw any inference simply from the fact that a lawyer objects to a question or that I sustained or overruled an objection. You must evaluate the evidence calmly and objectively without prejudice or sympathy. You must be completely fair and impartial. Your verdict must be based solely on the evidence developed at this trial or the lack of evidence. Our system of justice cannot work unless you reach your verdict through a fair and impartial consideration of the evidence. Under your oath as jurors, you are not to be swayed by sympathy or prejudice. You are to be guided solely by the evidence in this case, and the crucial bottom line question that you must ask yourself as you sift through the evidence is, has the government proven each element of the charges against Mr. Martoma beyond a reasonable doubt? we will stop there. Get back to this later. Next, we'll practice some literary material. This is called Social Media and the Court Reporter. Ready? Here we go. Technology has no doubt created a world where information can be accessed at incredible speeds and opinions and thoughts are disseminated to others simply by the click of a mouse or a keyboard. Whether you are providing remote cart services or broadcast captioning, or you are working as an official or freelance reporter, chances are you have used some form of technology to do your job. Since the advent of the internet, technology has continued to evolve and social media has become its cornerstone. Merriam-Webster defines social media as a collective of online communications channels dedicated to community-based input, interaction, content sharing, and collaboration. It is so commonplace now, and its use is so widespread that businesses set up websites as well as Facebook pages to promote their business. Government officials use Twitter so that constituents may be informed on current issues. Social media has become such an integral part of our society now that state and federal governments have actually promulgated rules and policies to address the concerns that social media potentially brings to the court system. Jurors are now instructed that they are not to use any form of social media to research the cases on which they're serving or communicate about them. Jurors are further cautioned about the consequences if these rules are not followed. While court reporters serve a different function in the legal setting, the rules that apply to the jurors are equally important to follow. As a court reporter, our Code of Professional Ethics does not specifically address the do's and don'ts of social media. It does, however, state that we are to guard against not only the fact but the appearance of impropriety. We must preserve the confidentiality and ensure the security of information, oral or written, entrusted to the member by any of the parties in a proceeding, and we must maintain the integrity of the reporting profession. Engaging in discussions on social media regarding any matter that we have reported not only would make us guilty of misconduct, but also could potentially cause irreparable harm to the parties. In order to respond to the needs of our society, we need to stay abreast of current trends in technology, use video conferencing, Skype, live streaming, and the like in order to provide the best product or service that you can, and then at the end of the day, relax, share your photos of your family and pets, your favorite recipes, and your thoughts. Let's remember to keep the social in social media. Let's get back to our jury charge. Ready? Here we go. It is for you alone to decide whether the government has proven that Mr. Martoma is guilty of the crimes charged, and you are to do so solely on the basis of the evidence and subject to the law as I explain it to you. If you let fear or prejudice or bias or sympathy interfere with your thinking, there is a risk that you will not arrive at a true and just verdict. If you have a reasonable doubt as to Mr. Martoma's guilt, you should not hesitate for any reason to reach a verdict of not guilty. But, on the other hand, if you should find that the government has met its burden of proving beyond a reasonable doubt that Mr. Martoma is guilty, you should not hesitate because of sympathy or any other reason to reach a verdict of guilty. The question of possible punishment of Mr. Martoma must not enter into or influence your deliberations in any way. The duty of imposing a sentence rests exclusively upon me. Your function is to weigh the evidence in the case and to determine whether or not Mr. Martoma has been proven guilty beyond a reasonable doubt solely on the basis of such evidence or lack of evidence. Under your oath as jurors, you cannot allow a consideration of the punishment that may be imposed on Mr. Martoma if he is convicted to influence your verdict in any way or in any sense to enter into your deliberations. Similarly, you cannot permit any feelings you might have about the nature of the crimes charged to interfere with your decision-making process. Your verdict must be based exclusively upon the evidence or the lack of evidence in this case. In reaching your verdict, you must remember that all parties stand equal before a jury in the courts of the United States. The fact that the government is a party and that the prosecution is brought in the name of the United States does not entitle the government or its witnesses to any greater consideration than that accorded to any other party. By the same token, you must give it no less consideration. In reaching your decision as to whether the government sustained its burden of proof, you may not consider any personal feelings you may have about Mr. Martoma's race, religion, ethnicity, national origin, sex, or age. All persons are entitled to the same presumption of innocence. Mr. Martoma has pleaded not guilty. In doing so, he has denied the charges in the indictment. As a result, the government has the burden of proving the charges against him beyond a reasonable doubt. The burden of proof never shifts to a defendant for the simple reason that the law never imposes upon a defendant in a criminal case the burden or duty of testifying, of calling any witness, or of locating or producing any evidence. A defendant does not have to prove his innocence. To the contrary, Mr. Martoma is presumed innocent until such time, if ever, that you as a jury are satisfied that the government has proven him guilty beyond a reasonable doubt. Mr. Martoma began the trial here with a clean slate. This presumption of innocence alone is sufficient to acquit a defendant unless you as jurors are unanimously convinced beyond a reasonable doubt of his guilt, after a careful and impartial consideration of all of the evidence. If the government fails to sustain its burden, you must find Mr. Martoma not guilty. I will now address reasonable doubt. What is reasonable doubt? It is a doubt founded in reason as opposed to a doubt based on speculation, emotion, sympathy, or prejudice. It is a doubt that arises out of the evidence in the case or the lack of evidence. It is doubt that a reasonable person has after carefully weighing all the evidence. Reasonable doubt is a doubt that arises from your own judgment, life experience, and common sense when applied to the evidence. If, after a fair and impartial consideration of all the evidence, you are not satisfied of the guilt of Mr. Martoma, that is, if you do not have an abiding conviction of his guilt, you must find him not guilty. In other words, if you have such a doubt as would cause you, as a prudent person, to hesitate before acting in matters of importance to yourself, then you have a reasonable doubt, and it is your duty to find Mr. Martoma not guilty. On the other hand, if, after a fair and impartial consideration of all the evidence, you do have an abiding conviction of Mr. Martoma's guilt, in other words, a conviction you would be willing to act upon without hesitation in important matters in your own life, then you have no reasonable doubt, and it is your duty to find Mr. Martoma guilty. Reasonable doubt is not whim or speculation. It is not an excuse to avoid the performance of an unpleasant duty. Reasonable doubt also does not mean beyond all possible doubt. It is practically impossible for a person to be absolutely and completely convinced of any disputed fact that by its nature is not susceptible to mathematical certainty. As a result, the law in a criminal case is that it is sufficient for the government to establish the guilt of a defendant beyond a reasonable doubt, not beyond all possible doubt. In determining the facts, you must rely on your own recollection of the evidence. The evidence in this case is the testimony of the witnesses, the exhibits received in evidence, and the stipulations or agreements as to certain facts entered into by the parties. When I sustained an objection to a question, the answer that the witness may have given in response to that question is not part of the evidence in this case and may not be considered by you. You are likewise not to consider a lawyer's questions as evidence. It is the witness's answers that are evidence, not the questions. All right, let's see what else we have for a little more literary practice. This is called New Twists on Deductibles. Options can help keep premiums lower for homeowners. Ready? Here we go. The definition of deductible used to be simple. It was the dollar amount stated in your homeowner's insurance policy that you would pay to repair property damage before your insurance coverage would kick in. In other words, if you had a $500 deductible and a fire caused $5,000 worth of damage to your kitchen, you'd pay the first $500 to fix it, and your insurance company would pay the remaining $4,500. But insurance companies have recently started offering different types of deductibles, making the matter more complex. What's happening with deductibles these days? Following are three major trends. Higher deductibles. Deductibles based on a flat dollar amount have been creeping up in the past few years. Where a $250 amount used to be relatively common, many insurance companies now encourage their customers to take on at least a $500 or even a $1,000 deductible. In fact, some insurers don't even offer the lower deductibles anymore, but they aren't the only ones driving this trend. During the recession of 2007 to 2009, and the subsequent recovery period, many homeowners chose higher deductibles to keep their monthly insurance payments down. Those people often found they were comfortable paying a higher deductible even after their financial situations improved. Split deductibles. Insurance companies offer this type of deductible for people who want different deductibles for different types of losses. For example, in some regions of the country, insurers will allow you to have one deductible for wind and hail damage and another for everything else. The Interinsurance Exchange of the Automobile Club recently started offering split deductibles to members of the Auto Club of Southern California. One deductible for covered water damage losses and the other for any other covered losses. All right, that will conclude our literary and jury charge practice.